Welcome to today's webinar. So what I wanted to talk about today are co-parents and college expenses, because oftentimes as family law practitioners, we constantly deal with the issue of child support for dependent children, but post-secondary support, college expenses, vocational school is often not thought about until the child's about that age. And so I wanted to address that today because that seems to be coming up more and more often. So a question we often get is, are separated parents required to pay for children's college expenses? And the answer to that question is it depends. And there are several factors on which it depends. The first thing I would advise everyone to do who has a co-parent with dependent children is to look at your existing child support order. In the mandatory form that exists today, Section 17, which I've highlighted below here, addresses post-secondary support. So with respect to the mandatory form as of today, you must address the issue, but you can either reserve it, it can be granted, or it can be denied. And even if it is granted within the order, you can state it will be decided later. So yes, we agree to pay. We'll decide what that means at a later date. So we have had situations where parents agreed that yes, they wanted to ensure their children's college expenses were covered even when the kids were 2, 3, 4 years old, and they just never modified the order. So you could have an order existing from 14, 15, 16 years ago that obligates you to a post-secondary payment, but doesn't define what the expenses are, but does say, yes, it is awarded. So how you share those expenses is likely going to be the biggest issue when you do want to address post-secondary support. In many instances, your child support order will reserve the issue. For those that were entered prior to the mandatory forms being created, it might not address it at all. So how do you address who pays for college if you want to pay for it, or you want to ensure that your co-parent pays for it, or that you're jointly obligated in some way? Either you or your co-parent will need to file a petition to modify the support order to address post-secondary support. And the reservation clause, Section 17 of the existing order, does show you exactly how to do that. It's Form FL Modify 501, and it has to be filed before child support ends. So you can't file this either after the child graduates or turns 18 in many instances, whichever is later. So if they took a gap year, now they're 19 years old, you likely have missed the window. Now, if you request it, is the court going to order one of you or both of you to pay support? And the answer is they're not required to. So RCW 2619090 subsection 2 says when considering whether to order post-secondary support, the court must determine whether that child is in fact dependent and relying on the parents for the reasonable necessities of life. Now, you could have a very dependent child who's been working, wants to pay on their own way, isn't really dependent on parents for anything at this point. And in which case, maybe the court will say this child is he's self-supporting, very independent. Or that may turn on how long they order either of you to support it. But, age, the child's needs, the expectation as to whether the child was going to go to a post-secondary institution. These are all things the court will look at in consideration of whether they are going to make a post-secondary award. So let's say the court says, yes, we do think that you both should be obligated to contribute to your child's post-secondary support. So how do they determine the amount? With your child support order for dependent children, the child support schedule is mandatory. So that would determine a transfer payment. That's not the case for post-secondary support. So the statute specifically says that it is advisory and not mandatory for post-secondary support. So you do have to file a child support worksheet identifying, the income and whatever deductions you're allowed that would show you what a transfer payment would be and what the proportionate share of income is between you and your co-parent. But the court does not have to use that to determine what percentage share each of you should pay, for example. So what the court will look at is income, expenses on your financial declaration, and the financial resources of both parents in determining a fair split. And this makes sense because, particularly as people are having children later in life, there might be larger age discrepancies between parents. You might have somebody living on a fixed retirement income, but with a plethora of financial resources available to them. So would it be fair to assign their income as their fixed retirement income, which is likely to be very low when they have millions of dollars available to them in investments, for example? And the answer is probably not, but it's subject to the judicial officer who's making the decision. The other questions that we have are, what if my child leaves school? What are the payment requirements? And the statute addresses this to some extent to say that your child must be enrolled in academic or vocational school, actively pursuing a course of study commensurate with their goals, and must be in good academic standing as defined by the institution. And this is, the language is a little squishy, I'd like to say, but because a course of study commensurate with your child's vocational goals does not mean they can take, lacrosse as a class and expect that parents are going to pay for infinity amount of time while we take these extracurricular classes, even though they may be in good standing. Also, periods in which the child may be suspended or even on leave would fail to comply with these conditions. So if they're suspended, you wouldn't be obligated to pay as the parent. Now, if your child simply is performing poorly, you can't put into your child support order when post-secondary support is awarded that they must maintain a certain GPA. That's not uncommon. I would suggest that it be a reasonable GPA. So, a B average or something like that. And you're not required to simply rely on what your child is telling you about how they are performing in school, because both you and your co-parent are permitted to review all academic records and grades of whatever post-secondary institution, certainly when you're required to pay for post-secondary support. And another question that we get quite often is that, my child is likely going to be in school until they're 35 years old. There's master's degrees, there's PhDs, Juris Doctorate, for example. And the court has also addressed this to some extent, where payment should not go beyond the child's 23rd birthday, unless there are exceptional circumstances that would make that a reasonable request. But essentially, the goal of post-secondary support is to provide your child with a foundation, a platform to get maybe that bachelor's degree, or work in a trade, a vocational institution, for example. But anything beyond that is really up to them. You can agree, again, outside of this to cover, a year of a master's program or some time in a PhD program. But ultimately, the goal of post-secondary support is to give your child that initial footing. If they decide that they want to pursue additional courses of study rather than test the job market, then they've kind of reached adulthood at that point, and they should be able to make those types of decisions. So the court's not going to require you to do that. and again, statutorily 23 is the age they have chosen, but that's the age where the court has kind of said, you know, you're adult enough to make these decisions and determine if you, child, are capable of, if it's your desire to await the job market and obtain additional education. Another question we often receive is, okay, well, if I have to contribute and co-parent has to contribute, does my child have to contribute anything? And again, the answer is, it depends. And the court will look, again, at financial resources of both parents. If both parents are extremely well off, for example, and have a lot of financial resources available to them, they might not require the child to contribute. Though a lot of judicial officers do want the child to have some sort of investment into their own education. So, you know, a 1/3, 1/3, 1/3 split is pretty typical, you know, or 25 and work out the other 75% between the two parents. But there also might be a 529 plan. Maybe grandma and grandpa started a college fund. There could be a requirement that the child apply for grants or scholarships. Ultimately, it comes down to what would be the fair division or a fair suggestion in terms of what the child is able to contribute. So unfortunately, as with many questions surrounding litigation, the answer is always going to be, it depends, but these are the factors necessary to review for the court to make a decision. Another question, to which the answer is it depends. Is there a cap on tuition? Now, oftentimes, I would say about 80% of post-secondary support cases that I have dealt with personally, the court will cap tuition in Washington State based on the in-state tuition of a University of Washington student. So resident tuition is used as the limit for a lot of circumstances. However, if there is a legacy history, for example, if every person in the family went to Harvard or Yale or some Ivy League institution and that's on the table, then it is very possible and probably likely the court is going to require whatever post-secondary award be applied to that amount of tuition. Also, was the plan for the child to go to an out-of-state private institution that's much more expensive? So if there has been support from the parents, I mean, financially, emotionally, and otherwise, for the child to go out of state to a more expensive private institution, would it be fair to then say, yeah, we'll support him, but only 25% of what we've always wanted him to do? That's probably not fair. So it's important, you know, as you're thinking about post-secondary support, to think about what do you want for your child? What does your child want for themselves? And that's hard to do when the child's 2 or 3 or 4 years old, but that's something that it's worth a conversation, certainly when they're little, you know, when they're in elementary, when they're in middle school, when they're in high school. These are all things that are worth talking about. And with respect to any additional questions that anybody might have about post-secondary support or how to acquire it or whether it was addressed in your initial order, I have my contact info up here on the screen and always welcome calls or requests for information. All right, thank you.